Good afternoon, Your Honor. If it please the court, my name is Christy Morrison and I represent the defendant, PepsiCo Inc., who has recently become aware of the astronomical default judgment that was entered in this case. We motion for relief from default and default judgment under Rules 55C, 60B1, and 60B4, using theories of excusable neglect and the potential that the judgment is void. Apparently, this litigation actually began back in April, and my client was not alerted to the case until sometime around September 18th. I'm not sure whether there was invalid service or what caused this miscommunication, but I assure you that my client is very interested in defending against these claims. As some background, around September 18th, Secretary Kathy Henry received a letter for her supervisor, Tom Tammany, and Kathy was preparing for an upcoming board meeting, so rather than logging it and forwarding the letter like she normally would, she set it aside because she was having a very busy day. Ms. Henry has been employed by PepsiCo Inc. for 20 years, and nothing like this has ever happened in the past. It was simply a mistake during an extremely busy day. When Ms. Henry received a copy of the plaintiff's motion for default judgment on October 5th, it triggered her memory of the letter on September 18th, and so she got both of those and forwarded that on to the legal department, prompting us to file this motion to set aside the default and default judgment. I assure Your Honor that this lawsuit is totally without merit. We are still reviewing the claims and gathering information. However, it is entirely possible that the statute of limitations has already run on these claims, which stem from as far back as 1981, so well over 20 years ago. And in addition, as mentioned earlier, there may be invalid service of process. In addition, the judgment award of $1.26 billion is equal to more than 20% of PepsiCo's reported annual profits in recent years. And quite frankly, we're not even sure how the plaintiffs arrived at that number. In addition, with an award this large, it would seem that public policy would definitely be in favor of deciding this case on the merits and not simply entering a dubious default judgment. For the aforementioned reasons, we would ask the court to set aside the default and default judgment due to excusable neglect, but in the alternative, under the assumption that the judgment is in fact void.